are watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
All rise. Hear ye. Supreme Court of Florida is now in session. All the way of cause to plead. Draw near. Give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Oh, wow.
Welcome to the Florida Supreme Court. Our first case for the day is Governor Scott versus Williams. You may proceed.
Thank you, Your Honor. May it please the Court, Raul Cantero of White & Case, along with David Godofsky of Alston Bird, and the Solicitor General for the State of Florida, Tim Osterhaus, for the appellants.
Mr. Cantero, as we get started this morning, and I'd like both sides to be sure we know what we're dealing with today.
Yes, Your Honor.
Well, I need to be sure on the record that we're all clear that this has no impact on individuals who's already retired. Is that the state's
Absolutely
position?
correct.
Has no impact on anyone who's already entered the DROP program.
Correct.
Because they've already, according to that plan, that fixes their retirement date.
That's correct.
And it does not deal with every conceivable collective bargaining agreement for individuals covered by different agreements throughout Florida.
I would go further, Your Honor, that the issue in this case does not concern whether any specific collective bargaining agreement has been violated.
Okay, and that question will remain open, and if
That's
somebody
correct.
has a question, and
that is not waived, and whoever wants to.
This is a general proposition.
The only issues here are the constitutionality, the facial constitutionality of what we call the plan amendments.
I just need to be sure that all of us in the record is absolutely clear, no doubt, no question.
Absolutely, and if you look at the complaint, does not raise an issue about any particular CBA. And
well, that's
order.
the way I read it. I understand that,
Yes.
but many times, as you know, things can get convoluted.
Yes. Right.
Once you start becoming involved in arguments,
and
we
one
need
of
to be
the
clear on the premise.
Yes, and one of the
issues really is collective bargaining as a whole.
Correct.
Whether or not this impairs collective bargaining as a whole.
That's absolutely right.
Okay.
I'd like to talk first about the contract clause provision, unless the court has no questions on that. But on the contract clause provision, obviously we rely on Florida sheriffs. We believe Florida sheriffs is directly on point.
On that question, but for the statute, is your understanding that the appellee's argument rests on the Florida statute that was interpreted in Florida sheriffs?
Yes, Your Honor.
So again, absent the statute, would there be another contractual claim that could be raised?
No, Your Honor.
So we're really, in a way, here. That's what I was on an issue of statutory interpretation, and your position is the Florida sheriffs has already resolve that issue.
Yes, Your Honor.
And is this the exact statute that we were talking about in Florida Sheriff's? I mean, there has
Yes.
been no change to that statute
None
whatsoever.
whatsoever. Not that part of the statute, the language that we're talking about. Before Florida Sheriff's and before that statute, this court had said that the state could, or any governmental agency could change benefits even retroactively. So what the statute did and how Florida Sheriff's interpreted the statute is that as a result of the preservation of rights provision, now the state can only change benefits prospectively. And I'd like to, what the court said in the opposite argument, they said that the opposite argument would in effect impose on the state the permanent responsibility for maintaining a retirement plan which could never be amended or repealed irrespective of the fiscal condition of the state.
Now, I guess the biggest thing that they're arguing is that by going from non-contributory to contributory, that was not the case in Florida Sheriff. So could you address, the COLA might be different, but as to making it a contributory plan, was that a vested right based on the statute that went into effect that really wasn't at issue in Florida Sheriff's?
The only way you can reach that conclusion is by essentially receding from Florida Sheriff's, because Florida Sheriff's drew a bright line and a clear line that the legislature can apply. Is it retroactive or is it prospective? If it's prospective, it's constitutional. If it's retroactive, it's not.
The trial court made the finding or the distinction that the changes that were made were qualitative in nature, and that's how she distinguished the Florida Sheriff's case.
Yes, Your Honor.
How do you respond to that?
That was exactly my next sentence, which is the court said that, and there's nothing, number one, there's nothing in Florida Sheriff's that makes a distinction between quantitative changes that would be upheld and qualitative changes that would be struck down. The court talked about retroactive versus prospective, and adopting that kind of a standard would make it unworkable and impossible of the legislature to determine whether a court is going to hold that changes are qualitative or quantitative or sufficiently qualitative to affect. Florida Sheriff drew a bright line. The legislature has relied on that bright line, not just in 2011 when it enacted the plan amendments, but all throughout since Florida Sheriff's in adopting other changes.
What would be the other changes from the time of the statute until this occurred have all been positive changes for employees of the
Right.
state of Florida. What would be, from the point of view of the legislature and the governor, anything that would be impermissible to do? For example, could the legislature decide to not have any mandatory pension plan?
As long as there's no retroactive effect.
So it could abolish the pension plan completely?
Yes, and I think the Florida Sheriff's either explicitly said that or implied that.
So
Not that would ever happen, but constitutionally they would be able to do it.
explain to me what you believe the language means in the statute, which talks about this is now a contractual right that employees are basically under a contract, and that those rights, those contractual rights, cannot be abridged in any way.
Employees are under an at-will contract. Most employees in the state, and of course we're leaving collective bargaining agreements aside, but most employees in the state aren't under a written contract, they're under an oral contract. So I would analogize it to an oral lease. It's not written. Oral leases are month to month, and the landlord can't say, I'm going to increase your monthly rental payment. You owe me for the last year another $10 a month, and going forward $10 a month. Obviously, a landlord can't do that, but a landlord can say, hey, starting next month, I'm going to increase your rent.
So under that kind of theory, the only option an employee would have is to say, I'm not going to be an employee anymore.
Yes.
I mean, the fact is, and I don't know if you specifically pointed out in your brief, and this is something that has struck me, the legislature could have decided in dealing with the shortfall, either lay off employees that would have equated with this, or could have reduced further their compensation.
That's right, Your Honor. They could have done that. And I want to emphasize that there was a $3.6 billion shortfall. This wasn't, the changes here did not make up for all that shortfall. It was only about 30% of it.
But we really don't, if we find that the statute doesn't vest contractual rights prospectively, the issue of whether they could have gotten, the legislature could have gotten the money elsewhere doesn't really, does that come into play?
No,
that only comes into play if we conclude that this creates a binding contract to not be able to alter benefits for anybody employed at the date the statute was changed for until they leave.
Yes.
Okay.
The only reason I recognize it is because this court in Florida Sheriffs addressed that issue and said we can't interpret the statute to freeze the Florida retirement system in time so that it can never be changed, because the legislature has to have the flexibility to react to changing financial circumstances.
But I guess it seems to me for us to get into, well, how it was a big hole that year, but the argument is, well, there were a lot of other sources to have gotten that income. It seems to me that would be involving this court. I mean, in some kind of a policy-making decision.
Correct. A judgment call about where you get the funds to make up for a shortfall. That's not something that any court gets involved in. That's a legislative prerogative. I want to also clarify, in case there's any confusion, that these changes do operate prospectively. The court below certainly assumed that, and although I think there's been some argument that there is retroactive application, I want to make sure the court understands that there is none. As far as the employee contribution, that's pretty clear. It only applies to earnings after June 30th of 2011.
How do you respond to the argument by the employees or the plaintiffs in this case that had the legislature intended for these rights not to pertain or not to apply to future benefits, that it would have used the word accrued in the preservation of rights statute?
The way I respond,
that would have solved it.
The way I respond is, as soon as this court's decision in Florida Sheriffs came out with that interpretation of the statute, there was no change to the statute necessary because the legislature agreed with the court's interpretation. The legislature has had 30 years to change the statute if it wanted to, but once it had that interpretation in Florida Sheriffs, it wasn't necessary.
I guess the problem, and I'm trying to figure this out, the statute, if the statute was changed, but the argument really would be that whatever was the rights vested at the time of the statute, and I guess the question is going to be, could the legislature change that statute, and therefore, assuming that it does vest rights prospectively, could the legislature then change that statute, or are they bound to whatever that statute says in 1972? Four.
Yeah. Well, we're not taking the position now that if the legislature changes the statute, then any benefits already accrued are no longer vested, because there was a contractual provision until now that they do vest retroactively.
Could you explain, because I thought that the collective bargaining issue was going to be an issue that would distinguish at least classes of employees. Whatever decision we reach, first of all, how does this impact counties and cities?
Because they are part of the FRS.
They are, but they were.
Let me clarify that. All the counties are part of it. Cities can be part of it, and many cities are, but some cities aren't.
But I thought there was some argument that the amicus raised that there might be differences in the cities and counties, that we should give them more flexibility, or whatever is decided here, for better or for worse, does that apply to all cities and counties?
It applies to them as far as your interpretation of the FRS is concerned, but it doesn't apply to any specific collective bargaining agreement and whatever arguments that people make that a collective bargaining agreement has been violated. That is not an issue.
So, in answer to an earlier question, did you say the legislature could, in fact, eliminate the retirement program completely?
Going forward, constitutionally.
And so that would mean also that the legislature could, in fact, increase the employee's contribution every year, couldn't they?
Theoretically, yes. Going forward, obviously not going backward. But I don't want to think about those things, Your Honor. We don't
well,
think
I'm sure the employees are.
On the issue of the collective bargaining rights, we also think that the changes do not impair any collective bargaining rights.
How does that work? Because I guess as judges, we don't engage in collective bargaining. But are there, in terms of police and firefighters, how do they get have the ability to negotiate for different percentages for their particular class of employees? I know there's certainly the special risk, but how does that work with the state collective bargaining?
The state employees all the state employees are in the Florida retirement system. So the system is what it is. The employees can negotiate on two different levels. They can negotiate for benefits over and above the FRS, either on a state level or on a county level or municipal level. And I'll give you just an example. Employees can bargain for the right for, let's say, police officers, any law enforcement officer, upon retirement, receive a $1,000 lump sum payment for each year of service. That's a retirement benefit that can still be negotiated.
But how does, if for the state of Florida, where the salaries are set, I guess I'm just trying to understand what rights, if the state can just eliminate the retirement plan, it's not much of a bargaining position.
Well, Your Honor, the Constitution doesn't guarantee success. It guarantees the right to collectively bargain.
But okay, well, I guess it's just but really not on the. How is it on the retirement plan? You're saying they could get more, but what's their?
Well, there's another provision as well I want to talk about, which is Chapter 447.3093 allows employees to bargain for a change in the statutes. And the governor or other executive of the bargaining agency, of the government agency, may request the legislature as part of a collective bargaining agreement to change the statute. That doesn't obviously require the legislature to do it, and oftentimes it requires appropriations. But there is a provision in the statute that allows employees in collective bargaining to bargain with their employers that a statute be changed, whether it's this one or any other statute.
What is the quid pro quo? What are they? If you don't change it, what happens?
If they don't change it, then the CBA retains is considered without those statutory changes. That's what the statute says.
You're now in your rebuttal time.
Thank you very much for reminding me, and I'll save the rest of my time for rebuttal.
Good morning. May it please the Court. My name is Ron Meyer. With me at council table is Lynn Hearn and Jennifer Bloom. Let me first address the sheriff's case. I think to understand sheriffs, you have to understand the facts that were presented in that case, because the language goes well beyond what the facts dictate. The facts were that in 1970, the special risk credit was set at 2%. That means that if an officer completed years of service in the future, he would get a 2% adjustment to his or her retirement benefit. In 1974, when the statute in question in this case, the Preservation of Rights statute, was passed, creating the non-contributory pension plan, there was a separate bill, Senate Bill 81, that was also passed that did two things. It raised the special risk credit from 2% to 3%, and it required those people who were receiving special risk credit to pay not the 6% that they previously had been paying, but 8%. Well, there was a conflict between the two statutes. On one hand, we had a statute that put the program in as a non-contributory program. On the other hand, we had a statute that said you would have to pay more contributions to get a higher special risk credit. And so that went through some angst, and the Attorney General ultimately decided that the 3% provision, the increase in the special risk, that could survive, but the contribution requirement, the 6% to 8%, couldn't survive because the plan was now non-contributory. So in essence, after paying the 8% contribution for about 3 or 4 months, they didn't have to pay it anymore, but they retained the 3%.
Where is that? That's not in the actual case, what you just recited, is it?
That's referred to in our brief.
No, I'm saying, but
no,
the
it's not
actual
referred
opinion.
to in the actual case. But the point here, Your Honor, is...
But I guess just going back to not being referred to in the actual case, since your argument, I guess, is that it's different because you cannot make a non-contributory plan contributory. That's the argument.
Very
right?
clearly, our position is when you read the plain language of the statute, which says that all of the benefits, the rights of members of the retirement system established by this chapter are declared to be of a contractual nature, those rights were to a mandatory, non-contributory system. And that's what the court in Sheriff's clearly recognized in
but
several
I guess
places.
that's where I'm having problem if they had obviously had the facts of what you're referring to, that there were 2 issues to be decided, and they decided, no, you couldn't make it contributory, then, I mean, obviously we'd either be receding or affirming that. So I have trouble, I guess.
I'm sorry. I perhaps misstated it then, because this was not an issue that was decided in Sheriff's. This was the issue that led to the claim in Sheriff's that you couldn't reduce that 3% back down to the 2% it was. And the reason that was being argued you couldn't is because this was a contractual benefit that you couldn't impair.
But there isn't anything in Sheriff's that says that they must keep a mandatory non-contributory plan, the state. It wasn't discussed.
Well, the court didn't address that, but in 2 places it talks about that the legislature has the authority to modify or alter prospectively the mandatory non-contributory retirement plan for
that's a pretty broad statement, isn't it?
Well, it's a broad statement, Your Honor, but what I think it very clearly indicates is in Sheriff's, they weren't adjudicating anything other than whether a years of service credit that hadn't been earned yet, there was no completion of the service required, could be changed, and the court said it could.
Mr. Meyer, I mean, I understand that you're doing the best you can on the facts of this case, and you, I think, devote more time to arguing in your brief that we should recede from Sheriff's because various reasons. But don't we, in looking at Sheriff's, don't we have to pay attention not just to all the facts that are swirling around there, and I'm not saying those are irrelevant, but we've got to pay attention, don't we, to the actual reasoning of the case and the rule that they state. And they state it repeatedly and unequivocally. They say, we stress that the rights provision was not intended to bind future legislatures from prospectively altering benefits which accrue for future state service. I don't know what could be a clearer statement of a rationale and the basis for the decision than that statement.
And that statement, Your Honor, flies right in the face of the settled law that says where there is a contractual right involved,
okay, so
you can bind future sessions.
So now we move on to whether we should recede from this holding and this rationale that is in this case. And I'd like to ask you to address an aspect of that. One of the things that you assert in your brief, in doing your analysis of whether it would be appropriate to recede from our decision in the Sheriff's case, is that there are no reliance interests. There's no detrimental reliance. And my question to you is, how can you assert that in face of the reality that the whole state budget is based on the decisions that were made with respect to this, and the whole state budget will be thrown out of balance, and the whole state budget will be thrown into chaos if we recede from that decision?
Now, Your Honor, you're making assumptions that were never part of the case here. There is no record evidence of that. At best, the record evidence shows there was a budgetary shortfall, and the legislature decided to make it up on the backs of public employees. Now, that is of record, but that's not the test, Your Honor. The test is the test in United States Trust, and as this Court has said in Childs, and that is to say that if you're going to, if the first thing you do is you identify whether there's a contract. We submit to you, and the trial court found very clearly that there was a contract. How could it be any more clear?
Wait a second here. But we're talking about, what I'm talking about, I know you got a lot of different arguments, but I'm talking about your specific argument that the factor related to the factors that we analyze when we decide whether to recede from a case. And one of those factors, which you acknowledge and discuss at some length in your brief, although I think you kind of go over this one too quickly, is the factor of reliance. And you essentially assert that there are no reliance interests here. And my question to you is, how can you possibly assert that? I mean, the legislature has obviously relied in the, not just in the decisions they've made this year, but in the decisions they've made previously where they've increased retirement benefits. And if they had known that we were going to pull the rug out from under them, they might have been more reluctant to increase retirement benefits that have been awarded in the years since sheriffs. Now, so I cannot fathom how there are no reliance interests that are implicated here.
The reliance interests, as we understand them, don't necessarily focus on whether the legislature relies, but rather what reliance has been made upon these particular cases or this particular case.
This is a case. Sheriffs is a case about the power of the legislature.
Right.
Now, when we make that decision, and then the legislature acts on the basis of their understanding of what that case permits and does not permit, it seems to me to fly in the face of reason to say that they haven't relied on it, or to take the position, well, it's just the legislature. We shouldn't be concerned about whether they've relied on what we've decided.
Your Honor, I think you've jumped me from the application of sheriffs into why sheriffs is wrong, and I'm happy to continue to discuss that.
I meant to do that.
I know you did, but I caught you.
I confess.
I want to go back for a moment, and I will address. What the trial court found was that there was a very clear contractual right.
Well, let me on findings. I thought this came up on summary judgment.
It did.
A finding, then, that's a legal conclusion.
Correct.
So what the trial court did, we have 7 of us looking at it. What we're doing, just let me make sure, is we look at that statute. Do you agree with Mr. Quintero that but for the statute, there is not an independent contractual right here?
There are cases that would suggest that there are contractual interests even in the absence of a statute.
But you're
in
relying
other
on the
jurisdictions.
statute.
But our case is centered on that statute.
And here's so the finding of the trial court is a legal conclusion.
Correct.
Not entitled to any deference.
Okay.
That's what we're here to do.
Correct.
If I read Florida sheriffs very broadly, when I had read the statute, I might look at that statute and say, I think that statute's very broad. But my problem is that we've got Florida sheriffs, which has been the law for 30 years and 40 years, whatever it is. And it seems to clearly state that changes can be made prospectively based on that statute. How do we, in light of that, unless we were to recede from Florida sheriffs, say that the statute trumps our interpretation of the statute in Florida sheriffs? Do you understand what I'm asking?
I do understand, but it's because the statute preserves the rights of the chapter, and the rights of the chapter that vest for an employee at the time of employment. The contract is between the employee and the Florida retirement, the state of Florida.
Now tell me this, because I'm trying to figure out, looking at this, if it wasn't, why would the legislature bind itself forever, no matter what the budget crisis was, to a plan that could not decrease benefits but only increase them? What would be other versus what Mr. Quintero says is that what was at stake is they couldn't retroactively go, and you've worked 30 years and now you're about to enjoy your retirement, and the State goes, so long, bye-bye, it's all gone. That, to me, of course, is a significant interest that every employee has, that what they've earned remains. But to say that they were binding themselves to never reduce benefits or require contributions, I'm just trying to, what would be the motivation that the legislature to give such a broad handcuff them forever?
It's a policy decision that the legislature can make and did make in 1974.
So they could
but
never, could they ever repeal that?
Well,
could they repeal the statute?
They could, but they can't repeal the vested contractual rights. Let me correct something that I think is in your assumption there, and that is that you can't ever change it, and that's simply not true. The legislature in Senate Bill 2100 did change the pension program created in this statute prospectively for employees coming on board after July 1st of 2011, and that's not in this case.
So
those employees can be asked to contribute.
Okay, so it's really a question of what our definition of prospective versus retroactive
Well, I
is.
think it's very clearly that, and
but
at what point
an employee. It's not employees that had again, I guess I'm trying to understand this, that it's employees don't have those retirement benefits until they work that day or week or year. So for their years of service will determine what they get. If the employer says you're gone,
right,
they get whatever they had as of the date that they're terminated.
But upon becoming employed, what the Preservation of Rights statute says is you have a right to a non-contributory system. Maybe you don't have the right to write it out for 2 years, but you have that right.
So
you can't take that right away without impairing the contract.
Do you distinguish them between the COLA provisions and the non-contributory?
No, I really don't, because
but wouldn't that be a better? I mean, that argument might.
It's a different argument, but again, the COLA...
It can't be the same argument, though.
The COLA was in the it is in the statute, Chapter 121, and was in the statute when the Preservation of Rights provision was enacted. So an employee who came in between 1974 and July 1, 2011, had a contractual entitlement to two things: a non-contributory system with a COLA. And all we're saying is you can't impair that contractual right. You can change it prospectively, and they did. They eliminated it prospectively for employees coming on board. They can change it if it's, they can make changes, so United States Trust case says, if they're insubstantial changes. And perhaps the 3%, 2% correction that was made under review in sheriffs would have been viewed as an insubstantial change. That wasn't decided.
How does that fit in with the notion that before you are entitled to anything, that you have to vest? So is there a difference between employees who have vested and employees who have not vested as to whether or not this statute is applicable?
We don't believe there is a difference, Your Honor.
You don't think there is?
No, because first of all, the statute doesn't talk about benefits already earned. Sheriffs pulled that out of thin air. The statute doesn't. The statute says rights of members of the retirement system established by the chapter. And the right of a vested or non-vested employee is to a non-contributory system with a COLA. So, I don't think the vesting issue...
But I guess I'm a little concerned about that, because it seems to me that you are not even entitled to the benefits of this unless you have, in fact, vested.
Well,
so
you're not
why
entitled...
wouldn't there be a difference?
You're not entitled to the benefits unless vested, because that's part of the chapter that's made a contract for you. In other words, you're living under the terms of the contract. That's not to say that you have a different contract when you're vested or not vested. The contract is for a non-contributory system with a COLA, and that's what's been impaired here.
So your argument really breaks down to prospective means only those employees who start their employment with the state as of the effective date of the new statute.
Yes, Your Honor.
So I imagine you disagree with the contention that hopefully will not ever happen, that the state could eliminate the plan completely?
We believe they could eliminate it completely prospectively.
But not for
the people who are in it. You can't change the game in the middle of the game, Your Honor. That's an impairment of contract, and that's prescribed by the Constitution.
But on that whole point, putting aside rights that people have under collective bargaining agreement, tenure, employees of the state can be discharged.
Of course they can.
There can be reductions in force.
Of course they can.
I have a hard time understanding how, when someone does not have a continuing right to employment, they have a continuing right to a particular benefit of employment. That strikes me as anomalous.
Even an employee who works a year has an entitlement to a non-contributory COLA provision. It may not produce any money for him because he hasn't vested, but that's the right that the Preservation of Rights Clause gives to him. And that right changes once he vests. Then he has a right to get money back when he gets fired or quits. And when he gets all the way to the end and he retires, he has a different right to a full retirement benefit, Your Honor. Let me use the last bit of my time to address this collective bargaining issue because it's so important. Article 1, Section 6 gives to public employees the right to collective bargaining. That's been construed by this court and others as being an effective right. In the City of Tallahassee case, this court said that one of the elements of a mandatory subject for collective bargaining is retirement benefits. And it struck down a statute that used to be in Chapter 447 that said public employees couldn't negotiate over pension benefits, found it unconstitutional as a clear abridgment or impairment of the right of collective bargaining. This statute didn't unambiguously and expressly ban collective bargaining. It clearly didn't do that, but its effect did, because what it did is rather than give the affected employees, which are all public employees, county, city, state, any subdivision, the right to have meaningful collective bargaining, to discuss it, to try and come to some agreement. As Mr. Cantero pointed out, there's a provision even to allow you to come to terms, get an agreement, and then go petition the legislature to exercise its discretion to implement that agreement. The point is, none of that occurred, and none of that could occur under this statute because the statute was simply crafted, dictated, and put into place without any right of public employees to negotiate over the change, to determine whether there are different alternatives that should be pursued. And that doesn't mean that they get, as Mr. Quintero says, Constitution doesn't require success. It clearly doesn't. But it does require the right to accord these employees collective bargaining. And this statute simply cuts off any meaningful collective bargaining right, and therefore there's a separate impairment issue here, an impairment of the right of public employees to have a voice in their wages, hours, and terms and conditions of employment, which means retirement, whether you're at the state or local government level.
So under the circumstances we have here, if the collective bargaining agreement prohibits changes in retirement, then that's an individual plan, and that plan could not be circumvented.
Well, that's true.
But if the plan has a clause that says this is subject to future legislative changes, then it would not protect against it. Isn't that really why that these collective bargaining agreements really are all different? I was a little surprised going through reading them at the vast differences for the same type of employment.
Well, they're all different.
It seems to be saying that.
Well, they're all different because different groups of public employees go to their employers, and there are different needs and
I understand,
and
but the point is that these contracts, am I misunderstanding it? Some of them seem as though they will protect against these kinds of changes, and others do not.
Well, some of them.
I mean, specifically.
That's absolutely true, and yet,
so why would we not then look to those to enforce the contractual rights that are there? I mean, it seems to me it strengthens your argument.
You can certainly do that, Your Honor.
But you just can't blanketly say that if I have a contract that says that the employer can do X, then when employer does X, you come in and say, well, that violates collective bargaining. I'm missing that.
No, you're not missing that. It's true that if there's a contract that protects against it, that's a different impairment issue. But the point I want to make and be clear on is the right of employees to effective collective bargaining isn't dependent upon the existence of a contract.
Well, how about, though, if it is contracted away?
If they gave it away, that's a different issue.
Okay, that's why you look to...
But, Your Honor, we never get there under this statute because they just simply, from Tallahassee High, said this is the system and there's no room to discuss it.
But my point is I'm trying to understand how, if a contract exists saying the employer can do this, how one could hold that violates someone's rights. I guess I'm not asking...
If there's a contract that exists that says we have bargained and give up our right to negotiate over these changes.
A clause, it's not going to say that. It's going to say something to the effect...
The legislature can change
can alter the benefits.
That's a different circumstance.
Right, but I mean, if that's the case...
But that's not the abridgment of collective bargaining that we're talking about.
But even if we have a contract...
an abridgment.
But again, if that's the circumstance... You can have what you're saying. You can have a constitutional violation of your rights, even though you've contracted that away.
Conceivably, yes. You'd have to look at.
So there's no waiver, no consent.
Well, you'd have to. Those would start getting into as applied challenges.
Well, I understand. That's why it seems to me that I'm troubled by this.
But the facial problem with this statute, Your Honor, is there's no room for any collective bargaining.
Okay.
Thank you.
Well, first, I know that Justice Perry wanted to ask a question.
I did want to ask a question.
Perhaps I can answer it. I don't know.
Okay. It seems as if the employee's position is tantamount to analogous to a student entering college on a certain catalog.
On certain what?
Catalog. All right. Once he enters on that catalog, that becomes his contract. Now, that doesn't mean he's going to graduate, but the college cannot change the terms that upon which he enrolled. I think he's saying that this is analogous to the state. It's not necessarily that you're going to finish. You're not guaranteed to finish, but you cannot change as long as you're there.
There would be no right to a catalog anyway.
I'm just making
right.
I think
that's exactly. I think that is kind of the position they're taking, but under that same analogy, the university can change the catalog. There's no.
They can change it, but it wouldn't affect the student.
The classes that he took before.
Precisely.
Yes.
Nor going forward.
Correct. Yes.
So isn't that's what's happening here? The state is basically changing.
I haven't thought about that specific analogy. The one I was making that I thought was on point is to a month-to-month.
I understand
lease.
that, but I think that's a little different though.
Okay.
Because the employee has the contractual right once he's employed, and whether it vests or not, and as long as he's there, it seems to me as if the provision will still be applicable to him.
Well, this court in Florida Sheriff's said it, and as I think Justice Kennedy quoted it, I was going to quote as well. We stress that the rights provision was not intended to bind future legislatures from prospectively altering
I understand
benefits.
And I'm saying the same thing.
Yes.
You can prospectively change it, but not to those employees that were there.
Well, that's not what. That leads me to another statement. My opponent was saying that in Florida Sheriff's, it didn't apply to those employees, but in fact, in Florida Sheriff's, the legislature reduced the percentage of credit from 3% to 2%, even for those employees that remain in the system, not for new employees coming in, but specifically for employees that are still in the system, as long as it was prospective and not retroactive. So Florida Sheriff's precludes that argument.
Well, I guess but the argument was is that there's a difference, not this qualitative, but the two elements of the plan has to be that it's non-contributory and that it has COLA. That's what I thought, the special risk would be a different
it's a different provision, but the same principles apply.
But Florida Sheriff's didn't deal.
With this
with the
specific
non-contributory or contributory.
Correct, but it didn't speak in terms of qualitative changes or anything like that. It was very clear about retroactive versus prospective, and it gives the legislature very clear guidance on what it can do to react to changing financial circumstances.
When it comes to the percentage of whether you're going to decrease or increase the state employees' pay, does the right of collective bargaining require that the legislature or some entity go first collectively bargain with the particular public employees union before they make that
No,
change?
Your Honor, and this court in the State versus PBA case specifically in a footnote declined to require the legislature when it was going to change benefits, and in that case there was a change of benefits. The collective bargaining agreement was going to provide for annual leave of 17 1/3 hours a month, and the legislature changed it to 13 hours a month. And this court said, we're not going to require the legislature, before it makes that kind of change, to go and negotiate with all the bargaining units. It would be impossible.
Well, so then I guess, and I see you're out of time, I'm still not sure then on collective bargaining. If they have the right to bargain regarding retirement, you don't agree with the idea that someone on behalf of the state has to first try to negotiate with the public employees. Maybe they'd say, listen, please leave our pension, but you can reduce our pay, or something that would be, because this is more meaningful for these reasons.
Your Honor, it's unworkable, it's impossible, because not only are there 11 state bargaining units that bargain with the state, but there's also a myriad, literally hundreds of bargaining units on the county and local level that they would have to negotiate with, because the FRS doesn't apply just to state employees. It applies to every county, school boards, universities, and many municipalities, over 100 municipalities. How can you negotiate with all those to make a change to the FRS?
Thank you for your arguments.
We would ask you to reverse. Thank you very much.
The next case on our docket for the day are amendments to the rules regulating the Florida Bar.
They're not here for the amendments case?
There Richard is.
Please exit quickly and quietly.
As the volume increases.
Quietly ain't gonna happen.
It really needs to be.
I think we're ready now, Mr.
I thought they were all here for me.
I did too.
It's not very interesting. Advertising.
May it please the court. I'm Barry Richard, representing the Florida Bar. In response to this court's instructions, the Florida Bar requested its board review committee to do a complete review of the bar's advertising rules and to recommend changes to this court. The Bar Review Committee, under the chairmanship of Carl Schwait, who is with me at council table, made the determination that it would be best to begin with a clean slate. The rules over many decades had been changed on a hodgepodge fashion, and the result was that they were unclear and sometimes had the appearance of being inconsistent, and the defense of the rules in federal courts was expensive. So the committee decided that it would be best to begin from scratch and review each rule or each concept to determine whether or not it ought to be retained, whether or not the language ought to be changed to make it clearer and more in compliance with federal jurisprudence, and then to restructure the rules to make them more simple.
Can I, on this, as far as approach, does the bar's position is that TV ads, names on buses, billboards, is to be treated the same as a Greenberg Traurig's website?
Yes, Your Honor, with some specific exceptions.
I guess, and I look like over the years, I think I've expressed my view about TV advertising as and bus. Well, I may not have mentioned buses, but it just seems that attorneys' websites, especially the fact that this is a new era, is just in a different category than, from a point of view of the harm that can occur, than the kind of television ads that we see fairly pervasively and around the state from a very small group of attorneys.
I understand that, Your Honor, and the committee was cognizant of that and attempted to deal with it. But to understand how they dealt with it, we have to begin with a core premise, which is that the United States Supreme Court over the past 50 years has given us a very clear set of guidelines as to what a state can and cannot do when it comes to regulating bar advertising. Some of those guidelines are not particularly palatable to many of the bar associations or Supreme Courts in the United States, but nevertheless, those are the rules. And the court has admonished and struck down rules time and again.
No, and I understand that. What I don't understand is why do we need to put websites in the same category as that they're advertising? And I know someone said, well, it's not really, it's marketing versus advertising. I think there is to me, there's a distinction in the way the public sees it. So it's not that I'm suggesting more restrictions for websites. I'm questioning, and I guess it's the position of some of the commentators, that why do we need it, other than the false, obviously no one wants to have false and misleading statements, but other than that, why do we need the regulation of the websites?
I appreciate that's what you're saying, and here's the reason. The reason we began with that is because the core lesson from the United States Supreme Court is the only things that we can regulate are deception, factually deceptive statements which can be prohibited because they have no protection under the U.S. Constitution, and we can regulate but not prohibit potentially misleading statements, and we can regulate but not prohibit. We can prohibit to some extent, but not entirely, unduly manipulative or intrusive advertising. Once you accept that premise, there's no reason why there should be any distinction. If something is deceptive, it doesn't make any difference whether it's deceptive in a newspaper advertisement, or at least this was the board's consideration, or on a website.
Did the board find, though, any indication, looking at all the websites, all the large firms, small firms, probably every firm has one these days, I would suspect, any indication that there was examples of false and misleading statements or deceptions?
The answer to that question is the bar does not have an accumulated record of that because the bar has been operating under a rule in which it effectively did not review websites as it does other advertising. But
Have there been complaints about websites?
There are complaints from time to time, but the committee was fully cognizant of your concern, and this is what they did, which the committee considered to be a fair balance. What they did was they said, we are not going to say that you can be deceptive or unduly manipulative on a website, but we recognize the distinction. And so here's what we're going to do to have a fair balance. We are not going to require that website advertising or websites be filed with the bar. Firms can file portions of them. They don't permit them to file the entire website because it's hundreds of thousands of lines of text.
I just want to stop you on website advertising. There's a difference, as I'm learning, that there's such a thing as internet advertising where you can put an ad on somebody else's website, I guess, or whatever that is. We're not talking. We're just talking about
I understand.
A website. So you consider the bar is considering the website of a law firm advertising.
Yes. The term advertising under these new rules applies to all solicitations for legal business. So that includes a website. But there's a second part to what the bar did in order to balance this. In addition to not requiring that the websites be filed, so that the bar would only become aware of this if it received a complaint or if it otherwise became aware of a problem, it also has applied to those aspects of the websites in which it would be significant and that worried the law firms what we call the takedown rule. So a law firm or a lawyer cannot be disciplined for certain aspects of the website, in particular under 4-7.4 and 4-7.5, which is potentially misleading advertising and unduly or manipulative, until it has been notified by the bar that the bar considers it to be a noncompliance and it fails to take it down within a given number of days. So nobody can be disciplined for anything on a website until they receive notice, they have the full opportunity for appeal that's provided under the rules, and they fail to take it down, assuming that decision by the bar is not reversed. Anything else involves deception. And therefore, the committee felt that in the case of outright deception, there was no reason to apply the takedown rule. So the concerns over firms that have significant website advertising really is not a concern that's well-founded, because they're not subject to discipline unless the bar advises them that it considers some aspect of it to be in violation and gives them an opportunity to change it or to appeal.
Now, in changing the rules to make it sort of fit one size fits all, and as I understand it, one of the reasons the bar never required the filing of websites is there just is not the manpower or person power to do that. But what is now going to be allowed in television advertising that wasn't allowed before?
The only thing that was not allowed before that will be allowed now, the old rule prohibited any background sound, and it prohibited in very vague terms certain types of dramatizations. Under the United States Supreme Court jurisprudence, we cannot do that. The United States Supreme Court has said that dramatizations, pictures, sounds, those things can be effective and communicated to the public what the lawyer does and gaining attention. And the Supreme Court has told us that the mere fact that an ad is effective because it uses devices to get attention is not sufficient to remove it.
Yeah, go ahead. I'm just shaking my head thinking about music and all of those other things.
What we've done is we have said that you cannot utilize those things in a manner which is unduly deceptive. And I understand that some of the comments that we've received say that that's too vague. And in the Harrell case, the court found that the term manipulative, which is all that was in the rule, was too vague. In order to overcome those problems, what the committee is suggesting and what the proposed rules provide is that it follows the structure that all of the rules now follow. It begins by a statement of the conduct that is regulated, the rule itself. That's followed by a non-exclusive list of specific examples of conduct that is prohibited or regulated by the rule, and this list in each instance is based upon the bar's experience with those aspects, those types of conduct that have most frequently come to its attention either because of disciplinary problems or because of requests for advisory opinions. And then third, there follows commentary to give additional guidance. So each of the rules follow that pattern, and they are designed to give the advertising lawyer the best information, the best guidance, and not only advertising lawyer, but the advertising committee, which must interpret these rules, because one of the problems we had in Harrell is the court said that they were not interpreted. The advisory opinions themselves were not consistent over the years. So they are designed to give the greatest guidance that can be given without tying the hands of the bar to anticipate future types of advertising that can't be anticipated or provided for specifically in every one of the rules.
At one point, there was, seemed to me that there were Florida lawyers who were concerned about advertisements in the state from lawyers who were out of state, and that to some extent the in-state lawyers' hands were tied. And do these rules help at all to address that kind of situation?
They do, Your Honor. And let me address the concerns that those firms voiced. One of them was the belief that well, first let me tell you what the rule does. The rule provides at the beginning, 4-7.1a, provides that these rules are applicable to Florida licensed lawyers and to out-of-state lawyers who advertise for legal business to be conducted in the state of Florida or that direct the advertising at Florida residents. Now, I need to point out that there is a potential problem with that last phrase, which I take responsibility for because I wrote it. We recognize that under the United States Constitution, the state of Florida cannot regulate conduct in other states, even if it involves Florida residents. And that's not what was intended. This, by the way, is carried forward from the current rule. What it's intended to say, and what the bar has always interpreted it to say, is that advertising directed at Florida residents for the purpose of performing legal services within the state of Florida. It's not intended that this rule apply to conduct outside the state of Florida, whether or not there's a Florida resident involved. One of the comments that was made was that this rule violates the Dormant Commerce Clause, the federal Dormant Commerce Clause, which essentially says that the state cannot discriminate against out-of-state interests, which this rule does not, because it applies equally to in-state and out-of-state lawyers. So it clearly doesn't violate the Dormant Commerce Clause. There was a concern that by applying this rule to out-of-state lawyers on the Internet, that this would have an adverse impact upon law firms that advertise, that are national in scope or multi-state and that advertise on the Internet. The committee believes that this problem has been mitigated by the two things that I mentioned earlier, the fact that Internet sites do not have to be filed and the takedown rule. So that the concern, and by the way, we also believe that the things that are prohibited, which is deception and inherently misleading advertisements, are the same effectively in all states. The concern was that a bar would not have to be continually changing its website and would have to comply with different rules in different states. We don't believe that would happen. There is no state that permits deception in advertisement. There is no state that permits inherently misleading. The only thing you can do with inherently misleading, by the way, is require that there be a disclaimer that avoids the inherently misleading nature. So we don't think that there's going to be a problem with complying in different states. And if that problem occurred, the bar would deal with it in its interpretation.
As we're dealing this morning with this entire area, we're dealing with prohibitions, regulation, but it's always of something that is misleading or false, something that's untruthful. I'm not of the view that just because Justice Wells sat on this court that it's misleading for him to have a business card that says retired Justice Charles Wells or any other judge who has served honorably in this state for a number of years. I guess even if I accept the bar's view that, this can be abused and it can be used so that it presents a picture of a person having special relationship with some judicial body. But why isn't the suggestion that those retired judges have suggested that as long as it's not used for that purpose, to not just absolutely prohibit retired judges from so indicating. Am I clear on my question?
Yes, I understand. And I need to precede this by telling you that there was not unanimity on this issue. There are differences among members of the committee itself, among members of the Board of Governors, and among members of the bar as to this rule. And it is presented to this court for the court's consideration. What the bar did was it doesn't prohibit entirely the communication of the information that an individual is a former judge. What it prohibits is the use of the term judge or justice along with the name. For example, on a brief or on a letterhead. But it permits a judge in any kind of a biographical presentation.
Well, again, a business card.
It would prohibit it on the business card.
Right. I mean, to me, if we are trying to stop deception, I mean, that's the antithesis. That's stopping the truth.
I think because of the difference of opinion within the bar, I cannot present...
That's true? I mean, I just can't... This is like either he sat here or he didn't, and I sat here with him for 10 years. I know he sat here. I mean, I can't see how there can be a difference of opinion as to whether it's true that, and I just use Justice Wells because it came to mind, any of the retired, Justice Harding or any of them, Justice Anstead, who sat there. I just can't, it's beyond me, and I can't accept even for argument that it's untruthful that that's what they did.
Well, it is not untruthful, of course.
And it's not deceptive.
And it is not deceptive, and that's not what the purpose was of this rule. For those,
but it prohibits it.
Well, for those...
Isn't the suggestion that it implies something that is inaccurate? It necessarily implies that the retired public official, because this doesn't just apply to judges, it applies to legislators and executive branch officials, that the retired government official has some special influence or entree to the courts. And that's the rationale behind it. My question about that is, why is that so? Why can't it be seen as simply implying that they've got experience, that they had that position? You know, if the former governor of Florida wants to have his face on a billboard and say former governor and his name associated with a law firm, I don't understand why that is inherently deceptive or a bad thing.
Well, this court's going to have a difficult time arguing with me over this because I can't dispute what you're saying. You have correctly characterized the concern of those people who favor this rule. And
but
I'm
again,
not taking a position on this.
But it comes back to, I mean, that then necessarily suggests that we believe that we have nothing but corrupt institutions. I mean, that's what that's saying, is that, you know, if you put judge or governor on, that every governmental body is corrupt because they can be influenced by improper things. It's like I don't know, it's an un-American view that we're all, I mean, everything is corrupt.
Because I think, and I probably have the opposite view on this, that what because we dealt with this in the context of how pleadings are to be filed, that as I understood it, it's just that the title wouldn't be former Justice Major Harding of here. There's nothing that would prohibit even on the card, you know, if you're board certified, to be able to put on former Justice of the United States Supreme Court. So it's just in the title. I don't know if Arthur England still makes people refer to him as Justice when he's, or whether he answers his phone Justice. But I think that had led to some concerns that came to us about not having it as part of their experience, but just part of their title. So do you see that? I mean, that's what I thought is the distinction, which would...
You're making an important distinction and an accurate one. As a matter of fact, Mr. Schwait just sent a little note over to me to make that same point. On the business card or on the letterhead, it can say Charles Wells, former Supreme Court Justice. It cannot say Justice Charles Wells.
Okay, so it's not then prohibited
That's
in
correct.
that fashion. Okay,
That's
well
correct.
then I was under the impression that it was prohibited.
No, it just requires that it say former and the name of the judge. And
we don't expect when Raul Quintero appears here that we're going to refer to him as Justice Quintero, nor do we want him to put on his pleading, Raul Quintero, Esquire, or former Justice Raul Quintero. And I think that, from my point of view, that's a concern. But obviously, everybody who's a former judge or justice, they're going to, if they use that in their marketing, it's certainly a good thing. So that's to me was
it's been my experience that former justices and even judges, when they appear before courts, do not use it. As a matter of fact, I remember Justice Grimes saying to me once, "Don't call me judge when I'm in court," and I said, "I'm sorry, I can't break that habit." So, and the reason that they do not do it is not, I believe, because they think they have any extra influence over this court, because we all know that they do not. The concern is the same one that underlines the rule on disqualification of a judge, which is the perception of the public and of opposing parties of the fact that that person might have undue influence. And we want
my question didn't deal with pleadings at all. I was asking about business cards.
Well,
and I don't know how we got into pleadings, because that's not what I would not envision. That's correct. It dealt with business cards only.
And I could have avoided probably a lot of talk if I had recalled that, in fact, we allow it on the business card as long as it says former or any other advertising.
Well, but what exactly does the prohibition in your proposed rule say?
It says that a judge...
Does it say a judicial, executive, or legislative branch title, with or without modifiers? There may not... This is something that's excluded. A judicial, executive, or legislative branch title, with or without modifiers, in reference to a current, former, or retired judicial, executive, or legislative branch official currently engaged in the practice of law? So the word title is what we're talking about?
It is only the title.
Well, judge is a title. Whether it comes before or after, it seems like to me. I don't understand. Maybe I've misunderstood. Maybe I don't understand what the word title means. But that seems to me that, regardless of its position in the sentence, it seems like to me that could be construed to a state representative, governor. The fact that it comes after the name means it's not a title? Is that the position you're taking? I don't mean that to be an anti. I'm just trying to understand this.
The intent of the rule, which of course is subject to modified language.
And let me say this: I realize that this is. I think we sent this to you. So
yes, you did.
Okay, so I just want to be clear that to the extent that we're there may be some second thoughts here about what we have suggested, or at least what some of us may have some second thoughts about what the court has previously suggested. So I want to make that clear. I'm sorry.
This, as you know, was a supplemental proposal based upon a request from this court. What the committee was attempting to do was to vocalize the concern of this court without unduly restricting the ability of former judges and justices to advise the public of that background.
Well, it seems to me that what you finally break down to is you cannot say Justice Charles Wells, but you can say Charles Wells, former Justice of the Florida Supreme Court.
That's correct, and I'll give you another instance in which this comes into play, which is currently before the bar, and that is a judge, for example, who is serving in the capacity as a former judge, a private judge. And the question was whether a person who does that regularly and has a business card or a letterhead can say, Judge so-and-so. And the bar's feeling was that was misleading.
How about Judge Alex and Judge all those TV judges? But this is before you, because you're going to run out of your time. I want to make sure: are we changing the rule on testimonials and past results for not only websites but for TV ads?
Yes, you're right.
Okay, so that when I was asking about to me, that's a major change. I think it may be a change if it's accurate and not misleading. Seems to me that someone having to be accurate about their past results is a far more informative way to communicate to the public than what mostly consists, like we're for the people or we're for the United States of America, or all that, those kind of advertisements that really say nothing.
I think those are probably the two most significant substantive changes in the rules, and they stem from this. Under United States Supreme Court precedent, we believe that you cannot entirely prohibit that. The Supreme Court has made it very clear that a statement of fact which is objectively verifiable...
Well, I think it's a good thing.
Cannot be prohibited.
I think
right.
In that way, versus music and catchy tunes, communicating information seems, and that's what the original intent was. Remember, the original intent for the U.S. Supreme Court was that lawyer advertising be clear to make available low-cost services to the public. And it's done everything but that was the original intent of why the Supreme Court said lawyer advertising was a good thing.
Right. Let me note what this does. With respect to past results, a lawyer can use it if it's objectively verifiable. Now, some of the commenters didn't like the term objectively verifiable, which they said was too vague. But in the first place, the United States Supreme Court has used those same terms. In the second place, I personally don't think that it's vague. One of the other comments about it was that it shifted the burden, which it does not. We recognize that the burden always lies with the bar to prove a violation.
What's the difference between verifiable and objectively verifiable?
Probably no difference, but the point, I can give you a difference in what is and is not objectively verifiable. For a person to say that I have the best record of any trial lawyer in Florida is not objectively verifiable for practical purposes, or verifiable. But to say I have an 80% record of success in the Second District Court of Appeal is verifiable. And the bar can request from the lawyer running that ad the documentation to establish that this is accurate, but the bar retains the burden if it decides to advise that firm that it is in violation of the rule. So there is no burden shift here.
And then the testimonials, because I think that was something that we were concerned. What was a testimonial? So what is a what can now an advertiser on TV, what can they do?
The advertisement can utilize another person to testify with respect to the lawyer's characteristics, whatever they may be, provided that the person who is giving the testimony has the experience and the expertise to be able to make that statement validly. So for example, and it depends on what it is. For example, a former client could say, the reason I like this lawyer is he always calls me back. Now, a client is perfectly capable of making that statement. And it's something, by the way, an overwhelming majority of the public on surveys have indicated that both of these things involve information that they would like to have about a lawyer.
No, I think those parts of the rule I think is good. I think that having responsible testimonials and responsible past results is information, as opposed to somebody who's a spokesperson who is saying something that is, it's just saying basically a jingle.
Well, so you can't get a celebrity, for example, who has never used the services of that law firm.
That's specifically prohibited, correct. You can use a lawyer who has expertise or who is a specialist in the field, for example, of trusteeships or of securities. Say that I'm a lawyer who is certified in the area of securities litigation, and I have been in court and utilized this lawyer on securities cases, and it's my belief that this lawyer is excellent and has the credentials to do the job. That's permitted under this rule, and I don't think under United States Supreme Court precedent we could sustain a prohibition any longer of that type of testimony. And in addition, the public overwhelmingly says that that's the kind of information it would like. In addition, by the way, it's very difficult to explain why you can say that privately. because one of the greatest sources of information on what lawyer to hire is asking another lawyer, but that the lawyer cannot say it publicly. I believe my time is up, unless the court has any additional questions.
So if someone want to use a celebrity, just have them as a client, pay him the dollar, and you can go ahead and say anything you want to say?
Well, the rule prohibits the use of a celebrity unless that celebrity happens to be in the unique position of having the information.
And if he's your client, he might be in that position.
If it's my client and that celebrity is speaking to things that a lay client, unless it's a lawyer with expertise, would have the experience and the knowledge to be able to testify to. So if for example, my firm's Atlanta office represents, strangely enough, country singers and rap singers, and if one of those celebrities happens to testify that they like to use our law firm because we're always accessible to them and we've always done a good job, they would be able to do that.
Can you
They just
have
can't
them
sing
do
it, right?
They might be able to sing it.
That's what I was thinking. You could
now
have
that we don't prohibit background music.
You could have a rap song on your. But you don't. I mean, the large firms are not the large commercial firms are not routinely doing television advertising. Your concern there is more what they're able to do on their websites to get business that is where the client is looking for a firm.
That's correct. Some large firms do television advertising. The bar has not had extensive disciplinary problems with those advertisements, however.
Thank you, Mr. Richard. If you do a rap on your website, I bet it gets a lot of hits.
Personally, don't do rap.
May it please the court. I'm Thomas R. Julin of Hunton & Williams. I'm representing Hunton & Williams and 7 other large law firms with approximately 6,500 lawyers. I really have 4 points that I would like you to consider here. One is that there should be an exemption from the advertising rules for websites. I think that the inclusion of websites within the advertising rule, it creates First Amendment problems, it creates Commerce Clause problems, and creating an exemption for the websites would eliminate those problems.
On that point one, what I'm understanding is the only thing you can't do is, or anyone can do now, is you can't be deceptive or inherently misleading. So you agree that you have no first. I mean, how is that a problem? I guess is
no. There's a continuing problem in that it's not only inherently or false and misleading advertising that is prohibited. There are provisions in this rule for potentially misleading and for unduly manipulative ads. Now, there's a takedown rule that has been imposed, but that doesn't change the rule. Under the bar rules, they do prohibit potentially misleading advertising and unduly manipulative advertising. Now, both of those provisions are vague, and they have problems with advertising generally, and trying to apply them to websites particularly is an enormous problem.
I still don't understand. I hear you saying the words, but I don't appreciate that there's a difference between the website or a newspaper that's both sitting on my desk, and they both do the same thing. Why the same standard should not apply? Well, if it is something that can be regulated, I understand them. If you can't regulate one, you can't regulate the other. But.
Yes, and fundamentally that is our position, that you can't prohibit potentially misleading or unduly manipulative ads wherever it occurs.
Okay.
And I'm simply saying when you try to apply those standards in the context of websites, it's an enormous problem, and that's what really.
Well, why? I don't understand that. I mean, we look at the page, we look at the printed page,
right? And the distinction is that websites are enormous. They're like encyclopedias now. They have grown up under a regime which initially.
All right, I accept that.
Yes,
and newspapers are thinner.
That's right. But
or non-existent.
That's right.
Right. But when you look at the standards there of potentially misleading and unduly manipulative, both of them are vague standards.
Well, are you saying that you want to be able to do those things?
No, what we're saying is we want clear and specific guidelines. And the clear and specific guidelines that are generally used, and this is seen in the ABA rules, is it prohibits false and misleading statements. And that's what the second point that I wanted to make is if you're not inclined simply to exempt websites from the advertising rules, an alternative that I would suggest is to look to the ABA rules. They are very distinct from what has been proposed by the Florida Bar. And what is most distinct about them is that they are simple and they are clear. They're literally 2 pages. And the structure, and this has recently been reviewed by the ABA just at the August annual meeting. It was looked at again. They adopted Resolution 105B that we just filed as notice of supplemental authority. And when you look at those rules, they're starkly different.
Do they distinguish between websites and television?
They don't expressly distinguish.
They don't exempt websites?
They don't do it in that way. What the ABA's rules do, they prohibit false and misleading communications generally, and then they allow advertising, and they then prohibit solicitations. And then comments make it clear that neither advertising nor website communications are regarded as prohibited solicitations. That's all they do. And in essence, what they're saying is false and misleading communications are what's prohibited. Now, the bar gets itself in trouble.
So are you saying there's a difference between misleading and inherently misleading?
No. There's a distinction between false and misleading communications and potentially misleading communications and unduly manipulative communications.
But you see, I guess the thing about it, and this is why I agree to some extent that maybe I disagree with Justice Lewis on this, that there is a difference in a TV ad and a website, in that someone has to go to a website. You do not have it in your face when you're watching morning TV. So that, and the idea, I don't know any website that employs jingles or kind of, I think that law firms would be laughed out of their client base if they, maybe not, but I've looked over I don't see anything. That's why I asked, where were the problems? I just haven't ever seen what I would consider a problem with the website. Whereas with ads, you put police officers on, people dressed as judges. It's there for the public to laugh about.
Right.
And so I do. And so to me, I would make a distinction, but I don't have a problem with unduly manipulative being applied to the TV ads, because I think it is a different medium and it has a different impact on, Marshall McLuhan said the media is the message. The message in a TV is different than a message on a website.
Well, and I don't disagree with you that there is a fundamental distinction between the 2 different media, that television is much more in your face, billboards, radio, that creates distinct problems from websites. Websites you have to search for, you have to find. That's why historically, when we first were dealing with websites, we were treating them as client-requested material. And there was a general exemption from most of the advertising rules for that website, which was regarded as client-requested material.
And we were thinking that by saying you had at least click on one click, that was going to be a good compromise, but no one seemed to like that.
Well, we like that is a good compromise. That if you're,
I thought no one. See, I thought after we adopted that everyone said that was bad.
No, not well. The original, back to the original rules. The home site was regulated, was subject to the advertising rules, and we didn't have a problem with that, and that's because it was fairly easy to make the home site comply with advertising rules. And then when you went beyond it and you went into all of the detailed information that was being provided, that's what created the primary problem, at least for the large law firms, in trying to comply with the rules. And the compliance is what really brought us here, and that's what I want to emphasize to you, is that these websites, they had been developed over the course of more than a decade. And they had been developed under a regime that did not subject them to the advertising rules. And so there are thousands and thousands of pages of materials that are created and they're out there. And that we're not.
Is it a concern that these thousands and thousands of pages may be in violation of the rule? Because it seems to me if you've got thousands and thousands of pages, The problem is going to be with the bar even being able to find anything that would be a violation of the rule.
Well, it's not so much a problem with the bar. The large law firms are very conservative institutions, and they want to do everything that they possibly can to comply with whatever rules are out there.
So are you saying that you don't think that these websites would now comply with the rules?
Oh, I think that they would, and what I'm here to argue to you is that that's not a good thing to have very conservative large law firms removing material because of concerns that it's not in compliance with very vague standards, because law firms will take the most conservative approach. They will take down lots of information about past results, about lawyers' awards, about all the things that might be treated as potentially misleading or unduly manipulative.
How could it be if a past result, and again, you're saying you're talking about conservative law firms, you either got the verdict or you defended this, it's either true or not true. You certainly would say, I mean, being in the best lawyers in America is verifiable. Being the best lawyer in Miami-Dade County, would we all agree that that would be not, I mean, there would be a lot of people claiming to be that. You couldn't put that on there.
Right. There are many lawsuits that everyone claims that they won. And it's very, and what...
Are you saying they didn't win?
You did or you didn't?
I mean, I think Willie Gary is famously known for saying he's won every lawsuit, only he's won some more than others. And I think that's a fundamental problem that lawyers face, particularly in conservative law firms, in trying to describe their services and trying to comply with vague standards. And so that's one of the principal reasons I'm saying take websites out of this. Keep it applicable to television ads and billboards and bus benches and so forth.
And what about the homepage?
The homepage, we could live with that in terms, I'm not saying that that's constitutional, I'm not saying that doesn't violate the First Amendment, but that's something
that's not a difficult thing to...
It's not a difficult thing to bring a homepage into compliance with, and then you can still have all of the information which we regard as very valuable to consumers, extremely valuable to consumers, even though some of our administrators might say, let's be very cautious, let's not put something there that might be regarded as potentially misleading or unduly manipulative.
The problem is, in today's internet world, you have advertisements shown on Facebook and all these different places, and you have pop-up videos. You can have all kinds of different things, advertising, all kind of different companies could use, lawyers as well, that really constitutes advertising and have the same presentation as what you would see in a television ad. There will be effectively no difference.
I agree with you, and that's a fundamental failing of the rules that the bar has proposed, because it doesn't distinguish between ads that you would see on, say, Amazon.com for Hunton & Williams and the Hunton & Williams website itself that someone has to search for.
Well, I thought it treated all the same.
It treats it all.
Web is advertising, and just like television and printed material, all these things are advertising, and they're all subject to the same rules. Do they not?
They do, and that's the problem.
Well, why is that? I still don't understand.
The reason that's the problem is that the websites are not commercial speech from a general perspective. The vast majority, if not all of websites, they're really not commercial speech under the United States Supreme Court standard. Commercial speech under the Supreme Court standard is speech that is doing nothing more than proposing a commercial transaction. When you put a label on a beer can, or you put an ad for the price of drugs, that's what the United States Supreme Court has said is advertising is commercial speech, and that's what lowers the standard under the First Amendment and allows for heavier regulation. When you look at these websites, again, they're not simply labels. They're not simply saying, Tom Julin is here and I'll offer you my services for $200 an hour. These are complex beasts.
But what's the purpose of it? I mean, you don't, websites aren't there as part of advertising to the public that these services your services are available? So what's the point of a website?
Well, certainly a part of it is that you want consumers, our potential clients, to know what we do. And so there is a commercial incentive to it, but that's not what transforms something into commercial speech. The Supreme Court, which has been tightening the rules even on commercial speech, and has been suggesting that they may ultimately subject commercial speech to strict scrutiny. In the most recent case, one of my cases, Sorrell versus IMS Health, the court talks about heightened scrutiny for even commercial speech because it's recognizing that there is such great value to commercial speech. In many instances, commercial speech is even more valuable than political speech. So that's what the concern here is, that if we have very vague rules and they're applied to websites, which are these complex, massive things, that you will have lost all the value of a lot of that speech because you have very conservative law firm administrators trying to comply with these rules. And now we do appreciate what the bar has done in revising the rules.
I want to make sure, because when I talk about internet advertising,
yes,
that's when you go onto someone else's website. You're asking that the website of the law firm be not under the same rules as other TV, radio, bus.
That is precisely correct. We see those as very distinct things, and that websites pose special problems. They do pose these Commerce Clause problems, which are not at all insignificant when we're dealing with these large law firms that have people practicing in Virginia, in New York, in California, and so forth. And then what they see is we have Florida bar rules, and those Florida bar rules are far stricter than the ABA's model rules, far stricter than rules in other states. And they're saying if you may not be in Florida, but if you're hoping to get some business from Florida, you're going to have to comply with our rules. What that essentially is doing, it's saying lawyers across the country, you may not be planning to come into Florida, but there are many lawyers in my Richmond office who are delighted to come into Florida if someone happens to come to our website and see that they have a particular specialty that is needed in Florida. And the way the bar rules now work, it means that they're going to have to comply with the Florida bar rules, which makes it far more difficult for out-of-state lawyers to compete with in-state lawyers because you have to be subjected to these heavy in-state regulations. That's one of the things that creates a serious Commerce Clause problem. So you're solving two problems by exempting websites. You're solving the First Amendment problem and you're solving the Commerce Clause problem. But again, what I wanted to leave you with is to consider the ABA rules. They're far less complex. They're simple. They're 2 pages. They're direct. They're used in most of the states. And where Florida is getting itself into trouble is trying to adopt these excessively complex rules. It's 20 pages of material. They do it in the name of trying to explain things better, but it really takes the focus off of what they're trying to do, which is to stop lawyers from making false and deceptive communications, to stop them from engaging in solicitation where the solicitation is likely to be in a coercive or duressful situation. That's where the focus of the ABA rules are. The Florida rules do something completely different, and they try to do way too much. In this instance, less would be more. Less regulation would be more regulation because it would give clear and specific guidelines to those people at our law firms that need to comply.
Thank you very much.
Good morning. I'm Joe Lang from Carlton Fields, and I'm here representing the comment of Carlton Fields and Bills and Sundberg, 2 Florida-based law firms that have national presences. We fully join and endorse everything Mr. Julin just said. We were part of the comment of the 8 law firms, but we have 2 distinct aspects of these proposed rules that we think unfairly treat Florida-based law firms, or could do that depending on how they get enforced and applied. The first aspect of that is how you would report past results or the quality of legal services as to a practice group or as to a firm at large. And we gave an example, and I think examples really help explain this. We gave an example in our comment of a white-collar practice group. We have a white-collar practice group. There are national firms that have white-collar practice groups, and we try to give information to or market to largely the same client base on a national scale. So if you have 10 members of a practice group at a firm outside of Florida and 10 members in a Florida practice group, probably all 10 members, at least 9 of the members at Carlton Fields will be Florida attorneys. So they will have, whatever we say in the aggregate as to the past results of the practice group or of the firm, it will have to comply with the Florida bar rules, these proposed rules, because 9 of the 10 or 10 of the 10 attorneys will be Florida attorneys who practice in Florida. A firm outside of Florida that has 10 attorneys, maybe one of which would ever practice in Florida, could aggregate their experience and give a summary of what the firm does or a summary of the practice group and the past results and not be affected by the rules. So that's the premise of where the problem starts. If we could treat websites as just client accessed communication as they have traditionally been treated, then we would have a level playing field.
What about what had been proposed by this court before we were told that wasn't what the bar wanted, which was the homepage is subject to the rules, but then if a client or a prospective client clicks on, gets the next page, that obviously still can't do false and misleading, but that the other provisions they're not considered advertising.
I think that would be far better than what is proposed here. I think ideally we would just have the websites fall under a different regime, not the advertising rules, but just subject to what currently exists, which is that you can't have false information, deceiving information. And
so let me see if I understood your example. Are you saying that as Florida lawyers, if you have a practice group, you cannot take all the lawyers in the practice group and say collectively what their results have been, as opposed to you can do that if you're outside of the state of Florida? Is that what I understood you to say?
I didn't finish how it all plays out.
Okay.
Both practice groups can do that, but the Florida-based firm will be subjected to these new rules if enacted. The firm outside of the state would not, because 9 of their 10 lawyers or all 10 of their lawyers are not Florida lawyers. And here is where we believe a problem comes up, is one portion of the new rule is not subject to the takedown requirement. 4-7.4 and 4-7.5 is subject to the takedown requirement, but 4-7.3 is where the past results section is, and that is the actually misleading or misrepresenting information. And the standard there, and this is where the crux is, the standard is objectively verifiable. And we believe without a definition in the rules as to what that means, that objectively verifiable can be different than true. And that, as a conservative law firm, without knowing how it's going to be enforced...
Help me understand that one.
Okay. Objectively verifiable is, we won this case and it's reported. The bar, without even coming to Carlton Fields and asking, how can you say that, could go on Westlaw and verify it themselves, could go on Google and verify it themselves. There are things that are 100% true. That's all we would put up, is something that is 100% true, but you can't go on Google and prove it. If objectively verifiable means that a third party can go and independently verify it with publicly available resources, then that's going to make us take a number of things down, or could make us take things down that are 100% true. Not
could you give an
example? That's what I'm trying to understand.
What? Like what?
Okay, we gave some examples. In our comment, we said that 50 cases settled without incarceration and satisfactorily declined. If you came and if the bar came and asked us, how can you say that, we could independently prove that that's accurate. There's no place the bar could go without coming to us and objectively verify on Google or independent resources what we're talking about or why that is true.
Well, they can objectively verify it through your office.
Right, and that's...
You would want us to put that clarification in. It wouldn't have to be verifiable by going on Westlaw.
And that's what our comment, it boils down to 2 solutions. Ideally, we would not have websites regulated under the advertising rules, but simply subjected to, they can't be false or misleading. But short of that, we would like a definition of objectively verifiable, that it means provable to the satisfaction of the bar if requested. And that was right in our comment, and that's the crux. Either a definition of objectively verifiable showing that it means that we can prove it.
What if they're unreasonably hard to satisfy?
What's that?
What if they're unreasonably to the a standard that is to the satisfaction of anybody else seems to me to be problematic. There ought to be some kind of reasonableness.
I agree with that. This is the quote right out of our comment, but I agree that a reasonableness requirement. But we think this definition is better than how it currently is, because objectively verifiable does not necessarily
now,
match up with
I just
true.
want to make, you would have the option to take the website where you're concerned and send it to the bar. Is that correct?
I don't think the bar wants hundreds or thousands of pages. I think.
Well,
we
I
could
wouldn't
say-
think that the past results, I mean, there could be hundreds of thousands of pages, but I would assume for your client, prospective client, you want to make it easy for them to see why they would want you over, Greenberg Traurig or something. So this thousands of pages thing is what I'm sort of.
Well,
but you could have that option, like say, I want to put in. We've settled 50 cases without incarceration or whatever, and you say, I want to make sure that meets your criteria. Yes, they can send it to you. Yes, they're saying yes. So it seems the conservative person says, I'm not sure yet. Let me make sure.
Here's the problem with that: is these websites are continually being updated as new past results are created, and we have practice groups, 20 practice groups in a firm. It's going to be an administrative nightmare having the past results page.
See, I guess everyone says these law firms are conservative. So I think a conservative law firm would make sure what they're putting on their web for their clients would be accurate. And, you're concerned about something that it seems like there's a boogeyman here that isn't really ever going to happen, but your argument is that's why that shouldn't be regulated.
Well, we are not going to put up anything untrue. I'm not worried that we're putting up something untrue and we need the bar, to verify for us that it's true enough or it has truthiness. What we put up is true. The problem is it objectively verifiable, or is it only provable if you come and ask us where is the evidence?
Well, that's assuming though that objectively verifiable is not the same as coming to ask.
And we just would like to have a definition.
Everything in the world, I guess you could put a definition to, but to me, I'm missing the lawyer argument that objectively verifiable is somehow so vague that you have no idea what that means. I'm missing that argument.
The argument is just a concern that if the rule says objectively verifiable, we have to read that in the most conservative way, which means that objectively, without asking Carlton Fields.
Well, see, I don't think I'm conservative on that reading, and I don't read it that way. That's what I'm saying. Is that it's beyond understanding that objectively verifiable means just one absolute thing and that's it. I'm missing that. I've never seen a case that says that. I mean, that to me is a very reasonable standard. It's not somebody's subjective determination. You understand the difference between subjective and objective. And verifiable is that you can determine whether it is, you can determine whether it's true or not.
It gives me great comfort that you feel that way. I would like a definition in the rule.
You would, at least if the opinion says that you're
right, is you don't want regulation of web pages. You want to. That's where this comes to, is that maybe not you, Mr. Lang, but that's what the underlying argument is here. We want to be free to do what we want to do on our web pages. And they've come up with arguments that this is somehow just all of a sudden has changed the whole world, that that's not a communication when you say that you're using it to try to get people to hire you.
Well, it is client access information, though. It's fundamentally different than the newspaper on the kitchen table or the TV ad. I mean, there's a client choice or a potential client choice to access a website.
Well, there's a potential client choice to pick up a newspaper. True?
I think that when you go to a website...
Well, I understand. There's whole arguments going with this. Folks can do all kinds of things with the Internet. I mean, you can solve the biggest problems in the world with the Internet, and you can also sell children through the Internet. So, I mean, this is where we get into trying to peel the onion so finely, is that we're missing the point of what this whole thing, and I think Mr. Swait and the bar and these folks have done a fantastic job in pulling this all together. They've done it better than I thought they would.
Thank you for your argument.
Thank you for your time.
May it please the Court, I'm James Green, West Palm Beach lawyer. I represent the ACLU of Florida and Searcy Denny, which is a plaintiff's personal injury firm in West Palm Beach and Tallahassee. I'd like to first address some of the vagueness issues of objectively verifiable. On my website, back in the late 70s, early 80s, I filed a number of jail conditions class actions, one of which was Bland versus Norville against the St. Lucie County Sheriff and the St. Lucie County Commissioners. That case was resolved by a consent decree. The case stayed active for approximately 10 years. It was closed out by Judge Payne approximately 22 years ago. Randy Berg from the Florida Justice Institute contacted me earlier this year and asked me for some, because he'd received some complaints from some inmates at the St. Lucie County Jail, asking me for copies of the pleadings. I couldn't find them from 32 years ago. I checked with the federal court. They have no copies of those documents. I've got that case listed as one of my past results. Is that objectively verifiable? I can swear that it happened, but I can't find any paperwork, either in the federal court, Westlaw, or in my office to indicate that it's objectively verifiable.
I guess under that standard, I could, at a future time, I could say that the Supreme Court of Florida never reversed me as a 4th District Court of Appeals judge.
and I couldn't find that on Westlaw.
I worry about the fact that I'll miss it one day.
Another example is confidential settlements. Confidential settlements encourage parties to settle cases. I have a client that has indicated on its website that it has settled cases for millions and millions of dollars. But some of those are confidential settlements and cannot objectively verify it if the bar came to my client.
Well, that's probably why it's confidential. They don't want you putting it on your website.
Well, as long as we don't say what happened, but if we can, I think my client can say that it's recovered millions and millions of dollars in settlements in a particular class of cases. But again, if you can come up with a definition that can capture those two examples and protect those two examples, then, and those are two examples of truthful speech, then that may work. I don't know. But I'd like to go on.
What do you suggest as the standard?
Pardon?
What do you suggest as the standard for measuring truthfulness?
Well, if a lawyer signs a declaration or an affidavit that he or she, in fact, handled the Bland versus Norville case and received a favorable consent decree in a class action on behalf of the inmates, then that might be okay.
And if the bar can't prove otherwise, is that not objectively verifiable?
If that's presumptive, if what
I
say...
I'm asking you. There must be a standard in the world that would apply to circumstances. And if you don't like the objectively verifiable, what standard would you want someone to apply?
Well, if you say that a lawyer's sworn declaration that he or she, in fact, handled a particular case and received a particular result is enough to be objectively verifiable, then that's fine. But that's not in the commentary.
So if it said verifiable as opposed to objectively, somehow objective is sounding like it has to be another source.
Yeah, an external source. It doesn't say externally verifiable, but it just say objectively. I don't know what it means.
But the other option is that in a situation like you have where it's 20, 30 years ago and you have any doubt about it, you could submit it to the bar to make sure you're okay with doing that.
And if they accept my sworn declaration, that's fine.
Well, if they say there's nothing wrong with it, then you're fine on it. I mean, that's what they're. I understand the.
Do you support what Mr. Julin said about a preference for an ABA type regulatory scheme, a simpler a scheme that just focuses on primarily misleading conduct and inappropriate solicitation?
Not wholeheartedly, to the extent that they carve websites out of the client solicitation provision. We support that. However, we take a much stronger position, and this is consistent with the 2004 task study, which said that we don't need to subject lawyer websites to the rules generally regulating advertising by lawyers. And also, the ABA basically said that after its most recent, fairly exhaustive study, that where it concluded that no new restrictions on lawyers' websites are necessary at this time.
So let me understand something. For the ABA model, are websites treated differently? They're not considered advertising?
Yes, in a somewhat different way than I'm going to argue, which is my main argument. If I can, I have 30 minutes of argument to make in like 3 minutes. If I can go into this,
you're over 10 seconds here.
Are you really finished?
About 1 minute.
1 minute.
I'd like to talk a little bit about the concept of push and pull. If I'm a lawyer and I put a banner advertisement on the web, or a pop-up on the web, or perhaps positioning, if the bar could empirically show that that is intrusive and manipulative or meets whatever other standards the bar has for advertising, I think those could constitutionally, under the current scheme on Central Hudson, which is, I think, slipping away based upon what Mr. Julin said about the Sorrell decision. But under Central Hudson, I think those could properly be regulated under the current state of the law as lawyer advertising. But all those do, they might get you to the website. They might get you to the website. But once you get to the website, that is much more akin to a client picking up a telephone and calling the lawyer, a client walking into the lawyer's office, a client meeting with the lawyer. Those conversations are considered client-solicited communications. When a client goes on the internet and uses a sophisticated search engine to search out a lawyer in West Palm Beach, Florida, who does personal injury cases, and then sees a number of websites on a Google screen, and clicks on one of those websites, that is much more akin to the lawyer picking up a telephone calling me, or the lawyer walking into my office and talking to me, or meeting me somewhere to talk to me. Right now, the bar does not regulate those telephonic, email, or office in-person communications, except by the general prohibition against false, misleading, or deceptive conduct. And we have no problem with client-solicited communications on the websites, on the emails, on face-to-face communications being governed by that general rule. That's been the long-standing rule that's governed websites and other client-solicited communications.
If you'd wrap it up, I'd appreciate it.
Pardon?
Please wrap it up.
Okay. And I'd like to in addition, I think one of the ways that courts have dealt with potential, and bars have regulated potentially deceptive information, is by requiring disclaimers. And I'd urge that the court consider those. I would also urge that the court not require disclaimers that are so burdensome that they swallow the overall message. And we'd ask that the court not regulate or treat websites, lawyer websites, just like they treat any other client-initiated or solicited communication. Thank you very much.
Your argument.
May it please the Court. My name is Tim Chinaris, and I represent the referral service 1-800-411-PAIN. Today we ask the Court to reject...
Where does PAIN... What is that
It's a
acronym?
medical and legal referral service, Your Honor. And today we're asking the Court to reject 3 proposed rules. The third required disclaimer for lawyer referral service ads, the rule regarding authority figures in ads, and the rule that allows the bar to arbitrarily revoke a finding of compliance with an ad, that an ad complies with the rules. First, we asked the court to reject the rule that the bar has proposed regarding a third disclaimer for lawyer referral service advertisements. Right now, the rules require 2 for lawyer referral services. This would add a third, and we think this would impose an unjustifiable and potentially unconstitutional burden on referral services that advertise via radio and TV. The trend in radio advertising is towards shorter and shorter ads, and to require 3 disclaimers in a 15-second ad really eliminates the ability to use that medium. The law puts the burden on the bar to justify restrictions on commercial speech by showing that there is a real harm and that the rule alleviates the harm to a material degree, and in this case the bar has not done that. The bar offers only the unsupported assertion that the public, without this disclaimer, might be misled into thinking that referral services refer cases to lawyers who haven't paid to join the service. And really, there's no evidence that the public thinks this way. For all we know, the public could assume that lawyers pay to belong to referral services, or the public may not care. We don't know. But the point is, and I think the important point for this court, is that the bar has the burden of producing evidence to show that there is a harm addressed by the rule, and the bar hasn't done that. In the Mason versus the Florida Bar case, the 11th Circuit refused to allow the bar to require a disclaimer where, just as here, the bar failed to show any concrete evidence of real harm. And in the Ibanez case and in the Zotterer case, the U.S. Supreme Court did recognize that at some point requiring disclaimers can become unduly burdensome and so violate the First Amendment by chilling commercial speech, and we think that is what this rule does. So we'd ask the court to reject this rule, and in the alternative, if the court is so inclined, to consider staying action on this referral service rule, because the bar is producing a comprehensive package of changes to the referral service rules. The second point is that we ask the court to reject the rule dealing with authority figures in ads. It's really vague as a matter of law, and it is unjustified by the report that the bar offers in support of it. The rule doesn't define the key term authority figures. Neither does the commentary. The bar has put in the rule the examples of judges and law enforcement officials, but they're only examples. The rule isn't limited to that situation, and so we think without further definition, it's just too vague of a standard to give fair notice to what is or is not required. It's also interesting that this is the one area in which the bar seems to think that disclaimers will not cure a potential problem. The bar's rules and proposed rules would allow disclaimers to deal with testimonials, to cure potential problems with dramatizations, with lists of past results, but not in this area for some reason. And it's interesting also that the bar for 6 years had repeatedly approved the use of ads with actors dressed as police officers and found no public harm during any of that time. And the survey they offered in justification really doesn't provide that evidence of harm. It deals with live, in-person encounters with people in uniform, and this rule goes much beyond that and deals with undefined authority figures who could be anyone, a coach, an older person, a parent. It just leaves the advertiser at the mercy of guessing, and we think that's too vague a standard. In the report, the author also kind of suggests that the idea of the most gullible consumer is a standard that should be used, and we, of course, think that is not justified by the law or by this Court's decisions. And finally, we think the Court should reject the rule dealing with the ability of the bar to revoke its findings of compliance for no reason. Right now, the bar issues interpretations, and the advertiser is entitled to rely on them and build ad campaigns around them, and that's what is done typically in the TV ad campaign area. It costs a lot of money, takes a lot of time, and we think that people that submit their ads ought to be able to rely on a finding of compliance where there's been no misrepresentation, no change in the underlying rule. We think they should rely on that for longer than the 30-day period proposed by the bar.
Thank you for your argument. The court will be in recess for 10 minutes.
All rise. Supreme Court of Florida is now in session. Please be seated.
Last case for the day is Patrick versus Gatian. Please proceed.
Thank you, Your Honor. May it please the Court, my name is Al Stanley. I have the pleasure of representing Ms. Patrick.
Would you please talk into the mic?
Yes. Better? Sorry. I have the pleasure of representing Ms. Patrick in this case. She's the appellant. And I guess at its essence, this is a case about counting. Simply, how do you count days in this sometimes labyrinth that is the Med-Mal statute? And more specifically, how do you account for or treat a 37-day period that arose under the facts of this case? I will tell you, I'll go straight to it. It is our contention in this case that when a plaintiff under 766-104, parent 2, buys an automatic extension, that no part of that extension should be counted as to 766-106, parent 4. No part of it, no way.
So quite frankly, what in the world then does the language mean that says that once your negotiations are over, you have what is either left of the statute of limitations period or you have 60 days? What does that language mean? And if you have 37, I thought it was 42, but whatever many days left on your statute of limitations period because you bought the 90 days, what in the world does that mean? It means you either, it seems clear to me, it means you either have the 37 days or you have the 60 days. Why isn't that correct?
Well, the problem is trying to harmonize these two statutes, which I believe was nicely done in the Cafaro opinion. And the problem is under 766-104, parent 2, there's a very specific commandment. And it says that automatic extension is in addition to any and all other tolling periods. There's only two tolling periods in 766-106, parent 4. That's the 90-day pre-suit, and then there's a 60-day period that follows that pre-suit. And so in order to give any effect or weight to 766-104, parent 2, and to harmonize them and give full effect, you can't read that one sentence in isolation. So yes,
so what does the sentence mean, or are you writing out with your interpretation that sentence that says you have what's left of the statute of limitations or the 60 days?
I think Cafaro answered that very nicely, and it said that the only way to harmonize that sentence with other provisions in the Med-Mal statute is to allow the full 90 days to be separate and apart and distinct from 766-106, parent 4. So I'm not asking that you ignore it.
So tell me, on October 31st, when the negotiations were over, what did you have left of how much time did you have left to file the complaint?
Well, I can tell you the way we calculated it based upon Cafaro, we felt we had until February 6th of 2007 to file the lawsuit.
Based on, just tell me.
That's based upon the 60 days under the statute and the 37 days left over from the extension.
The problem
so instead
we get
of
into
or
is
is
that, and we have different facts. That's the problem that you found yourself in. When I looked at this case initially, I must tell you, I thought you were correct. But as I started studying it, I think that you may have missed it, and I'd like you to tell me why those other cases, the time when you initiated the pre-suit process in the earlier cases was at a different point in time within the purchased extension. And so you don't have identical facts. We got that 37 days hanging out there that they're really not dealt with really under those earlier cases, it seems to me.
No, I don't think there's ever been this precise case where you have 53 days or some period of the extension being utilized to bridge you to your notice of intent and having something left over. The reason I think there's conflict in this case, quite frankly, is that if you applied the methodology of the first DCA or the trial judge to the facts of Cafaro or Nowitzki, you're going to get a different result. If any part of the 90 days had been running concurrently with the 60-day tolling provision, then you get a totally different result in those two cases. And that's why I think the methodology utilized by the first DCA is incorrect. This situation actually was foreseen and somewhat foretold by Justice Parente on page 868 of her concurring opinion, she specifically says that the timing of the purchase of the extension should not be the controlling factor, and that would lead to different results as to different plaintiffs. Yeah. And that's
what you have right here. I mean, that's what I'm seeing, but I don't know that we can go around the statute. I mean, I see it as a trap, but ours is not to agree or disagree with the statute. I mean, it says what it says, and to agree or disagree that it's created a matrix that you have to go through. But it's just you happen to be one of those that got caught on this, is what it looks like.
Well, when you say the statute is controlling, I would suggest that the controlling statute would be 104 parent 2. That says, it commands, it says, shall be in addition to any and all other tolling periods. And the periods is plural.
But you can see that this case is factually distinguishable from these other cases.
It is factually distinguishable in terms of timing, yes, sir.
Well, why is there express and direct conflict then? If there's a material factual distinction, and I don't, if it's an immaterial distinction, it doesn't matter. I mean, so I'm having trouble with understanding how there is express and direct conflict.
Because the logic and the rationale and the commandment of Cafaro was not followed by the first DCA. If the methodology employed by the first DCA, where they say that the statute of limitations commenced upon the termination of negotiations, if that methodology and that premise is applied to Cafaro or Nowitzki, you get an entirely different result.
But that has to be understood within the context they were speaking and given the facts. And sometimes the rationale is going to be the rationale regardless of the particular facts. But here it seems to be the rationale has got to be understood as pretty highly context dependent. I mean, because they're analyzing the question of the interaction of these statutes.
The other thing that I would say about that, when you look at the Hankey case, there is excellent language on pages 97 and 98 that talks about what tolling is, and it talks about 766-106 parent 4 as being a tolling statute, and that the 60-day provision is a tolling statute. And it goes into a wonderful explanation what tolling means. It means the clock stops, that you're not counting. That is directly adverse to the methodology utilized by the first DCA. I will reserve the rest of my time.
May it please the court. Good morning. My name is Michael Kendall, and I'm here this morning on behalf of Respondent Dr. Thomas Abbey. I know that the case is captioned Dr. Gadian, but Dr. Abbey is the defendant below who filed the motion for summary judgment in the trial court level and then the subsequent appeal of that decision. And so I have the pleasure of representing Dr. Abbey, and Dr. Abbey respectfully requests that this court find that because of the material factual differences, there is no conflict between the first DCA decision below and either Hillsborough County Hospital Authority v. Cafaro or the Nowitzki v. Hards case. And on that note, Dr. Abbey would further request that this court affirm the decision of the first DCA, which affirmed the trial court's order granting summary judgment.
Would you provide your analysis of those prior cases? Your opposition is saying, okay, we had this statute come out, then we had some cases come along, and those announced the principles of law that are applicable to how you add, subtract, and how you calculate times. And I believe his argument is that those cases establish certain tolling periods, certain times the statute runs, when it doesn't run, and if you follow the principles of law, it's not a red truck and a blue truck. This is a principle of law that if you apply those same ones to this case, factually, that the courts misapplied those standards. So would you respond to it in that fashion? Because certainly there are factual differences, but is there a principle of law here that is going to cause misapplication throughout the rest of Florida jurisprudence?
I don't believe that it will cause further misapplication.
Yeah.
And the part I'd like to direct the court to focus on from Cafaro, for example. In that particular case, the petitioner or the plaintiff had not purchased her extension under 766-104(2) at the time she dispatched her notices of intent to initiate litigation. And the Cafaro opinion was very specific and said that you do that analysis of how much time is going to be left later. You do that analysis when those notices of intent are received. So in Cafaro, that 90-day extension that was later purchased while the statute was told during the pre-suit period could not have been considered as part of the calculations because it hadn't even yet been purchased. So I do believe that there is a way to reconcile it all because the Cafaro opinion was very specific. It said that the 90-day extension that is purchased under 766-104(2) is not added to what remains on the original statute of limitations. So implicit in that holding is there has to be something remaining on the statute of limitations, the original statute of limitations, when those notices of intent are dispatched and received by prospective defendants.
And you're saying here that the plaintiff used up
absolutely
60 odd or 57 whatever days,
53 days of the purchased extension
of the extension.
Absolutely.
And therefore you can't go back and recapture that again.
Absolutely. The purchased extension in this case had to necessarily be applied to the natural expiration of the 2-year statute of limitations in order to keep petitioner's claims alive. 766, and it requires, as this court knows, the potential medical malpractice plaintiff has to complete the various pre-suit requirements within that 2-year period. And when they know or when they think they might not be able to, the statute allows them to purchase this extension. But this particular petitioner not only knew she wasn't going to be able to, so they purchased the extension, they used 53 days of the extension. So I don't want to oversimplify this with an analogy, but it's the only one I've successfully been able to come up with. But because we're talking about extensions, I logically went to extension courts. And so if that 90-day purchased extension under 766-104(2) is an extension that we're sitting over here in Cafaro because we're not using it because the plaintiff hasn't tapped into it yet. Second, they haven't even purchased it yet. But in our case, that extension cord has already been plugged in. That extension cord, that purchased extension under 766-104(2) has already been plugged in to the petitioner's 2-year statute of limitations, and it had to be because if it wasn't,
he filed the actual notice in July, right? And his statute had already run in June if he had not purchased the 90 days.
That's correct. The natural 2-year statute of limitations under 9511 would have expired June 10 of 2006. And the notice of intent was received by Dr. Abbey on August the 2nd of 2006.
I want to make sure about something because it sounds like what you're saying is reasonable. Obviously, there's a 2-year statute of limitations, and when the medical malpractice statute was amended, it was amended to require a lot of pre-suit, and the whole idea was we can't put the plaintiff in a trap to require all this, and then the statute expires. Explain to me how both Cafaro and this case are consistent and they're both fair to the plaintiff.
Sure.
Just in real world terms, so that because what we are trying to avoid is a trap for the plaintiff.
Absolutely.
And obviously here we might have lawyers who were trapped, but maybe they were trapped because of misunderstanding the law. So let's try to see how that goes.
Absolutely. And I will start by saying the reason I don't see it as a trap, respectfully, is because the Cafaro case, while I think petitioner has an argument in it as suggesting that maybe it stands for a proposition that it doesn't. I think that the petitioner is making Cafaro bigger than it was intended here. So the reason that this petitioner is not in a trap is because the Cafaro question was you look at the analysis of how much time is going to be left on the clock when this pre-suit period ends. You do that analysis when those notices of intent are received.
I mean, the whole idea is that the 2-year statute of limitations isn't 2 years and 150 days.
Correct.
In all cases.
Correct.
It may be that much, depending.
Correct.
Is that correct?
That's correct. And another reason why I think it makes sense is because if you petitioner in the brief suggested that this statute of limitations should be 90 plus 60. 90 being the pre-suit period if you're entitled to it all because it's doesn't terminate early with a written denial, 90 days for the purchased extension, and then 60 days under 766-106(4). The problem with that...
So that would be actually 210 days.
Correct. And the problem with that is it overlooks the question or the analysis that is required under 766-106(4), which is it less or is it greater than? What's remaining on the statute of limitations? So no plaintiff is entitled to the 60 days until that analysis is done, which then we ask ourselves how much time is left when the notices of intent are received. So I think it was I don't want to call it a simple calculation, but I think that's how we avoid the trap in future cases. And I don't believe there was a trap here. I think the calculation was when the notice of intent was dispatched and received by Respondent Dr. Abbey, it was received on August the 2nd. The question is, how much time do you have on your statute of limitations?
Is your argument that the 90-day purchase time is to assist the plaintiff in determining whether to file the notice of intent? Once it's filed, then that time is cut off.
Yes, I believe so. To the extent, I believe the 90-day purchase extension is there so that a potential plaintiff can continue investigations and can comply with the notice. I don't necessarily believe, though, that once you file that time is gone, because, for example, in a case where where a plaintiff is operating in their purchased extension, their 2 years has already expired, they're operating in their purchased extension, but if they only use 10 days, then the analysis comes back and says how much time is remaining on the statute of limitations. It's 80. 80 is greater than 60. So I don't think it's cut off. I think it goes back to the traditional analysis, whereas if this plaintiff didn't file...
It's only cut off to the extent you can't use it in addition to the 60.
Right, and I think that's because we're restricted by the language in 766, that 106.4 that says or. It's
well,
not.
Again, and I think I want to make sure there's fairness about this, because one of those real dilemmas for plaintiffs were getting something a month before the statute was going to run and having to do a reasonable investigation. How do you do that? And so there never should be a problem if you got the case towards the beginning of the 2 years. None of this should be a problem. These come up when there are claims that come to a plaintiff's attorney's attention closer to the end.
Absolutely, and I would agree. And the statute of limitations, that's not the case here in the case before this court, is because the statute of limitations began to run on June the 10th of 2004. We don't have a typical case where we're arguing over when did that statute of limitations trigger. Normally, defense attorneys are often saying, you knew that at this point, and plaintiffs are responding, no, we didn't know. But in this case, the petitioner has conceded both at the trial court level and at the appellate court level that shortly after the petitioner sent a request for her own medical records, that she would concede that she knew or should have known of the reasonable possibility of medical negligence. So we don't have a case where the lawyers came in late in the game because the client doesn't understand the law and came in at the last minute and said, please sue this doctor for me. Another reason why I think that I can say or I can ask this court to agree that there is no trap in this particular case, and that's because I think that the argument that is being put forth by the petitioner that they calculated on Cafaro, and so they calculated their days and they thought they had until February 7th because of the interpretation or the holding in Cafaro. I think it's a little disingenuous, and the reason I say that is because Cafaro came out in 2002. In 2003, the First District Court of Appeal came out with the decision of Cortez v. Williams, which this issue was not directly before the court. However, in that opinion, or in that case, Cortez was operating in the purchased extension. The plaintiff the 2 years had expired, they had purchased an extension, and they were in that purchased extension. When the pre-suit period ended naturally, because the 90 days expired because the defendant did not respond to the notice of intent, the First District Court of Appeal did exactly what they did in this case. They decided that based on the extended period of the statute of limitations, and in Cortez, that particular plaintiff had, I believe it was 16 days left on the extended statute of limitations. The First DCA said, so you're entitled to the 90 of the pre-suit, the 16 days is less than 60, so you're entitled to another 60 days. So that plaintiff had 150 days, pre-suit plus 60.
But you can get different statutes of limitation periods depending upon when the notice of the claim is provided to the physician. Mm-hmm. Because if you file it before the 2 years runs, you've got the 90 days plus then any purchased. But if you file it during a purchased extension, then you're going to have less than the full statute plus 90.
I would agree.
Yeah.
I would agree, but I think that the law is clear on that.
Well, no, I understand. I mean, but that is that could happen.
To hopefully answer that question and address Justice Periente's concern that we don't want to put people in a trap, I think that the law, albeit confusing, and the fact that I think Justice Periente noted in her concurring opinion in Cafaro that several of us, this was one of the reasons we went to law school, so that we didn't have to do these kinds of things. But I think we've made a lot of progress.
I said that?
I think you said something that this is what led us to law as opposed to accounting, because it's such a convoluted and complex process.
And it really shouldn't. I mean, the bottom line about this, I'm sure in this regard, I don't think I think they were trying to put something together that was reasonable to help plaintiffs and make sure the defendants had a chance to respond. It just does seem that what I don't want to see happen is that somehow there becomes some kind of game playing as to when a notice gets filed because, you want more time or you need more time. And so that's really my concern, is that we make sure that it is clear and why it's clear.
Sure.
That it not be because of something that is just manipulated by one side or the other.
And the reason I think it's clear here, and I hope that the court can take comfort in knowing that I don't think that affirming or finding that there's no conflict in affirming the First District Court of Appeal is in any way unfair to the plaintiff, because the calculations were set out when that notice of intent was received by Dr. Abbey. If one were to follow the analysis and the holding in Cafaro, the question had to be asked when that notice of intent was received by Respondent Abbey. And that notice of when it was received, the purchased extension was 53 days gone, and then we only had 37 days left.
You've done your public service. You have clarified any confusion for our colleague, Justice Periente. You can put that on your website.
So, with that being, and there will probably be confusion again. I don't know. I think it's all contingent on when certain things are filed, but I don't think that the confusion is necessarily the result of manipulation. I think the court can be eased in the sense that this was a calculation based on timing and based on the fact that this particular plaintiff had already used 53 days of her purchased extension when she dispatched her notices of intent to initiate litigation. So, for those reasons and for the reasons...
I just want to be clear on this. I was quoting Judge Blue of the Second District as to why this type of mathematical puzzle caused many of us to choose law rather than accounting. So I want to make sure if you're going to get a testimony, get it from Judge Blue.
So for those reasons and the reasons set forth in Respondent Abbey's answer brief, we would respectfully request that this court find that there is no conflict between the First District Court of Appeals decision and either Cafaro or the Nowitzki v. Hards case, and respectfully request that this court affirm the decision of the First District Court of Appeal. Thank you.
The bottom line is it's been 10 years since there's been this sort of a case before this court. And the reason for that is that Cafaro worked. It gave and provided guidance and predictability.
But isn't there a real difference when you have started your notice during your original 2-year statute of limitations period versus using part of your 90-day extension to send your notice? Isn't there a real difference in those two situations?
Well, I guess the problem is, analytically, how do you deal with the 37 days that remained? How do you account for that, and how do you allocate that time? Under Hankey, you're not allowed to apply any part of the 90-day purchase during that time frame. It's told. Under Cafaro, the 90-day extension is not to be applied then, too. So, analytically, I don't know how you can escape the fact that we should have gotten 60 days plus 37. If it really is a tolling provision.
But if he had, in this case, if there was the 90 days hadn't been purchased at the time that it was, your client would be out of court because the notice was filed after the 2-year statute of limitations period.
I fully understand. And again, conceptually, intellectually, how do you account for the 37 days? Is the plaintiff who purchased that extension not entitled to the benefit of their bargain as far as getting the full 90 days? And it seems to me Cafaro stands for the proposition very simply that no part of a 90-day extension that's purchased is going to be concurrently running with this 60-day provision at the end of pre-suit. That's what it stands for.
But this is a period beyond the running of the pre-suit. This is the period after the pre-suit is completed. I mean, I think your argument is correct as far as the pre-suit period, but this is that period after. Isn't that what we're talking about?
It is, Your Honor. Absolutely. But, again, the difficulty is in terms of trying to counter or give instruction to a paralegal, how do you do this? Cafaro gave us a very workable way to do that. And particularly in a case like this, you could tell them, okay, you're going to have 90-day pre-suit, you're going to have 60 days thereafter, and 90 days for what you bought. We feel like that we need the benefit of our bargain.
Is that? I mean, let me just to put this down in the real world. Were you the attorney below?
I was.
So what you're saying, I mean, and appreciating this, that you and or your paralegal assumed you had this time based on prior case law.
Based on two things, Cafaro, number one. Number two, the plain language of 766-104, parent 2, that says that that time frame, that extension shall be in addition to any other tolling periods, plural. So this
so
is
then a plaintiff, it seems to me that then a plaintiff who does everything within the 2-year time period, and then you get the negotiations are over, only has 60 days, right? Whereas a client who doesn't do it ends up with the 90 days and what you consider to be another 90 days.
Correct. I think that's what Cafaro says. It's what it stands for. That 90-day period, that extension is separate, distinct, and apart from any other tolling period. And that's the 90 pre-suit, and that's the 60 that follows.
I mean, here, it apparently, if the pre-suit, if the physician if they had denied within 10 days, still would have had only remaining under the remaining statute, either the 60 or the 37, but it says whichever is greater. I mean, that would have even pushed it to a lesser number of days.
You know, adopting some of the things that were in the appellee's brief, their argument that I can buy into on this level, they say that at the time of the termination of negotiations and the denial letter, that we had 0 days remaining because of what transpired earlier. Adopting that, if we have 0 days, 0 is less than 60, we should get the 60 and then the 37 that was remaining on the extension.
You would have 0 days left of what?
Of a statute of limitations. They speak consistently in terms of the original statute of limitations. They argued in their brief that at the time of the termination of negotiations that we had 0 days left.
Well, I think it's pretty clear that you had your 2 years plus 90 days and that you had used 50-some days of that 90 days. So I'm not sure I'm even following how you can get to 0 days left.
I was trying to give the court an example of what had been argued on behalf of the appellee and that how we would get 60 plus the 37 in addition to that. That's what I was trying to do. The last thing I'd like to say is, again, the Cortez case that the defense is relying upon is really not applicable at all. It has nothing to do with the interplay between the two statutes in question. Lastly, all the cases speak in terms of access to courts, in terms of promoting these statutes or interpreting them in a way that favors access to courts, and we'd ask that you very seriously enforce the rule of Cafaro and the statute that says that the 90-day extension is above and beyond, separate, distinct from any other tolling provision. The only way that statute can be given full force and effect and harmonized is that no part of the 90 days run concurrently with the 60-day tolling provision.
And so under your argument, what part did? what part of that 90 days ran within a tolling period?
According to the first DCA, the 37 days that we're arguing about ran concurrently with the 60-day tolling provision following the pre-suit. That was their analysis. They said that the statute of limitations clock recommenced. That's verbatim from their opinion, that the statute of limitations clock recommenced. That doesn't seem to make any sense if it's truly a tolling statute.
On October 31st?
November 1, yes.
Oh, November 1.
Yes. The first DCA specifically said the clock began to run again upon the termination of negotiations.
Well,
this doesn't make a lot of sense in a tolling provision. Pardon me?
I mean, under 766.104, either that 37 days you had to file your complaint, or you had 60 days to file your complaint. I mean, that seems to be what the plain language of that is.
That is the plain language of that statute. The problem with giving it that mechanical an application in this case, that totally ignores 766.104 parent 2, that commands that the time frame of the extension not be counted during a tolling period.
And the tolling period was the 90 days once you had filed your notice, correct?
There are two tolling periods.
Okay.
One is the 90 days.
What's the other tolling period?
Pardon me?
What was the other tolling period?
The first tolling period is the pre-suit, the 90 days. The second tolling period is the 60 days that follows the pre-suit. Those have been referred to repetitively as tolling provisions. Cafaro described it that way. Hank too. Well, there's only two available in this context. It's the 90 days and then the 60 days. I think the mistake that I recognize, and hopefully you concur, is that when the first DCA said that the statute of limitations commenced again upon the termination of negotiations, that's at odds with the 60-day provision being a tolling provision, which it's consistently been described as.
But why is it? Because it seems to me that, well, let's assume that you had, of your 90 days, you had 80 days left. So your argument would be that you have 80 days plus 60 to file your complaint, or you have 80 days?
It would.
That's your argument, okay.
That is. I mean, what I'm saying, and the way I started my argument today, was that when a plaintiff purchases this 90-day extension, under any circumstance, that should never be counted in one of the two tolling provisions that's set forth in 766.106 parent 4. There are two tolling provisions, and no part of the extension that's been purchased by the plaintiff should ever be counted or run concurrently with those tolling periods. To give literal effect to, you have 60 days or the statute of limitations, to give total mechanical application and effect to that, you have to ignore 766.104 parent 2 that says quite the opposite, that that time period shall be in addition to any other tolling periods.
Tolling period for that, giving that 60 days after the doctor's denied, putting that label on. Statute doesn't call it a tolling period.
The courts consistently have called it a tolling period. And in terms of 104, parent 2, it refers to tolling periods. Well, there's only two tolling periods that are available.
Well, that's if you assume that the period following the denial of the claim is in fact a tolling period. I was under the impression that the tolling period was during this suit activity.
Well,
so if your 90 days was totally gone, you would have the 60 days.
Correct.
So that's tolling what?
That's just the 60-day tolling period. If all the time had run out, if you'd used up your entire extension and you had no more time left, you would have 60 days to file your suit because it's a tolling period. Cafaro consistently...
Because you filed your notice on the 90th day, so you have no days left. You would have the 60 days to file your complaint.
Correct. Exactly. No, I feel I need to make it abundantly clear. I believe the 60-day time period that files pre-suit is a tolling period. And if you read carefully Cafaro, which I know you have and you will, and you also look at Hankey, it describes very clearly that that 60-day time period is a tolling period and that this extension business should be in addition to either one of the two tolling periods. So it looks like the case is now turning on whether or not the 60-day provision is indeed a tolling period. Because if it's tolled and the clock stops, then the first DCA's assumption that the 37 days should commence at that time doesn't make a lot of sense. And it's my contention the 60 days is a tolling provision. Thank you.
Board is adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.